Welcome to the Holland and Hart Health Law webinar series. Good morning if you're joining us in the Pacific time zone. My name is Derek Curl. I am a partner at Holland and Hart, and today we'll be covering the Telephone Consumer Protection Act, specifically navigating compliance with the TCPA in 2024. So welcome. By way of introduction, I've been at Holland and Hart for 16 years, and before that I was with a national firm. And for much of my time at Holland and Hart, I have advised clients on compliance with the TCPA, how clients can establish policies and procedures to comport with the requirements of the TCPA, as well as measures they can put in place to mitigate their TCPA risk. I specialize in representing businesses in complex litigation, and some of that litigation includes litigation involving TCPA-related claims and the TCPA state equivalence claims. My contact information is in this slide, and please feel free to reach out and connect with me on LinkedIn or by email. Ladies and gentlemen, this presentation is being recorded, and the recording and materials of this presentation will be made available within 24 to 48 hours after the presentation on YouTube and then on our H&H Health blog. It's www.hhhealthblog.com, and you can click on the webinar recordings there. If you have any questions during the presentation, you can submit them in the chat box, and I will try to address those questions towards the end of the presentation today. Just a quick disclaimer, this presentation today is providing general information on pertinent legal topics and is provided for educational purposes today. I'm not providing anybody any legal advice today. So let's dive into it. On today's agenda, I'll give you an overview, or for some of you who are familiar with the TCPA, a refresher of the TCPA and its key requirements in 2024. We'll take a look at TCPA enforcement and litigation trends under the statute, and we will examine recent and important legal developments, including the Facebook decision, and the case and statutory law in the wake of that landmark decision, which dramatically altered the TCPA landscape. We'll also cover the statute's exemptions, including some of the exemptions that are specific to healthcare and healthcare providers. And last but not least, we'll cover a few do's and don'ts of the TCPA. Okay, let's dive in. The Telephone Consumer Protection Act was enacted in 1991. It was enacted to combat, at the time, aggressive telemarketing and fax advertising, which the Congress believed was invading consumer privacy. The technology has come a long way since 1991, as you all well know, and so the TCPA is and has been interpreted to apply to this updated technology, which again applies to text messages and calls to mobile phones. Under the TCPA, the Congress empowered the Federal Communications Commission, or the FCC, to interpret the TCPA through rulemaking, regulations, and declaratory rulings, a few of which we'll talk about today. The FCC is extraordinarily active in those functions, and over the years, and including this year, has provided several rulings and updated regulations which make up the important body of law that surrounds and is the TCPA. Let's talk about the communications that are regulated by the TCPA. The TCPA and its implementing regulations make it unlawful to use an automatic telephone dialing system, or auto dialer, or artificial or pre-recorded voice to deliver calls or text messages to cell phones without prior express consent of the recipient. Now, the type of consent is driven and depend upon the nature of the communication. So if it's a telemarketing or advertising call, that requires prior express written consent. Non-telemarketing or information calls require prior express consent, which can take the form of being either written or oral. And we'll talk about what that means a little later on in our presentation today. The TCPA also regulates certain calls to numbers of individuals whose numbers are on the National Do Not Call Registry. And we're going to spend most of our time on these first areas, the auto dialer and artificial pre-recorded voice provision and the do not call provision. It does regulate some other areas, including artificial and pre-recorded voices to residential lines. It forbids fax advertisements. I know who uses a fax machine anymore, right? But it still nonetheless applies to fax machines. And it has some other related restrictions, including time of day when calls and frequency of which calls can be made. Let's talk about enforcement for a second. TCPA is enforced through the FCC, the FTC, states attorneys general, and private plaintiffs. But the single biggest risk for businesses and healthcare organizations is that from private litigation. The TCPA creates a private right of action whereby consumers may sue companies that violate the act. They may obtain statutory damages of $500 per call, or actual damages, whichever is greater, and up to $1,500 per call where the calls are found to be willful or knowing. An example of that is where calls are made after the called party has communicated that they don't want to receive more calls or text messages. Now, I know what you're thinking, $500 just doesn't sound like that much, but if you're making thousands of text messages or pre-recorded calls, this can add up very quickly. I have a simple arithmetic problem there. 10,000 text messages times $500 per call is a potential of $5 million in damages and up to $15 million if the conduct is found to be willful. There's no statutory cap on damages. Plaintiffs can also obtain injunctive relief. And because of the way the statute is set up, it is and has been fertile ground for class actions and is primarily the mechanism by which TCPA claims are brought in court. I wanted to give you a sort of sampling of recent TCPA class action settlements to give you a flavor of what these look like. DirecTV in the Central District of California in 2023 settled for $17 million, a class action which alleged pre-recorded messages to customers and, what was more concerning, numerous non-customers in violation of the TCPA. SiriusXM Radio, you know, the digital radio company, a $31.5 million settlement in the Northern District of Texas in 2019. These were telemarketing calls to customers whose names were on the do not call list and on the company's own do not call list. So these were customers who had told Sirius not to be contacted again, and they were nonetheless contacted through telemarketing calls. Keller Williams in Florida State Court in 2023, a $40 million settlement for unsolicited pre-recorded calls to consumers without their consent, including consumers whose names were on the do not call registry. And then National Grid, a utility company, $38 million out of the Eastern District of New York in 2022. The utility company was using pre-recorded and artificial voice calls to customers with no prior consent. These calls were related to bill payment. And then finally, and sadly, the Chicago Cubs were sued in federal court in Chicago for unsolicited text messages without prior consent to the plaintiff, who were soliciting him to buy tickets to Cubs games. As one legal commenter noted, the plaintiff must have been a Cardinals fan for this lawsuit to have occurred in the first place. So the poor Cubs in this situation. Let me bring this a little bit closer to home to the healthcare industry. There have been some settlements in the healthcare industry over the last few years involving CVS, the large pharmacy company, a $15 million settlement out of the Northern District of Illinois. This was flu shots and promotional calls made without prior consent. The problem with that, or one of the problems, was that they had mixed the flu shot reminders with a promotion, and that's a no-no. If you have a mix of or a dual purpose call, which is giving information or healthcare information with a promotion, it is deemed under the TCPA and by the courts to be a promotional call. And that's what happened there. Highmark Health is a health insurance company, and they were pre-recorded calls without consent, offering health care insurance options to individuals. That was the Western District of Pennsylvania. Adapt Health, this is a medical supply company, including supplying CPAP machines. They encouraged customers with text messages to order CPAP supplies without prior consent. They sent, remarkably in that instance, they sent 220,000 text messages after folks had told them to stop. That's an example of what, unfortunately, what not to do. A Place for Mom, which is a large senior living facility and care facility referral service. They made a $6 million verdict in the Northern District of Illinois, telemarketing calls without prior consent. And then Choice Health, another healthcare insurance provider, for making unsolicited calls to individuals on the Do Not Call registry. And this was in the Middle District of Alabama. So in 2024, that's the most recent, or one of the most recent healthcare related TCPA settlements. And you could hear from my description of these cases, these were all over the United States. They weren't limited to one specific jurisdiction. Wanted to also alert you and let you know about some filing trends that we've observed. This is an interesting graph. So this is showing a TCPA complaints over the last 5 years. You'll note a few things on this graph. One, obviously there's been a dramatic drop off from the 3,300 or so that there were in 2020, and there's a reason for that. One, the global pandemic had something to do with the diminishing TCPA claims and cases filed. The other is in part to the Facebook versus Dogood decision, which I mentioned altered the landscape, in which we will address in a moment. But notice, if you will, that the cases are trending upward, including 476 in the first quarter of the first quarter of 2024 alone, and a projection to approach 2,000 cases in 2024. So there is an upward trend of the TCPA cases, and I will tell you, and I will say this because I don't have the data, unfortunately, this does not reflect the dozens of cases which have been filed under the state mini TCPAs, which we'll talk about later in the presentation. So interesting graphic. There's an uptick happening right now in TCPA filed cases. And again, most of those, I will say, are class actions. Some individual, but most class action cases. So that's a quick detour to look at the trends and what's happening in the TCPA world right now. Let's get into the details of some of the portions of the TCPA itself and what's regulated. Let's talk about this component, this important component of the TCPA. automatic telephone dialing system. Interesting statutory definition, one that has been highly litigated, and we'll talk about the Facebook decision, which resolves some issues with respect to that. But it's been an important part of the TCPA from its inception. There's liability for using an ATDS to make telemarketing calls to cell phones without prior express written consent, and to make calls using an ATDS, informational calls without prior express consent is also prohibited. You'll notice that we have Homer Simpson's AT5000, which he used in his own telemarketing business. The technology, again, has come a very long way since those days. So this definition that I've shown you here it is not a picture of clarity. It's equipment which has the capacity to store and produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. This, what does capacity mean? Capacity presently, future capacity with some adjustments. This has been a hotly contested area, created a circuit split, which the Supreme Court resolved in the Facebook decision. In addition to the ATDS, I've mentioned artificial and pre-recorded voice are also an important part of the TCPA and its restrictions. Pre-recorded and artificial voice is what you can imagine it to be. You get a voicemail or you get a call from an entity where there is not a live person on the other line, but it is a recording. That's what they're talking about with artificial or pre-recorded voice. The other component, which is so important with the TCPA, is consent. I've mentioned it a couple of times already, but in the world of the TCPA, consent is king. The consent that you obtain can inoculate you from liability if you get the right consent. And if you have that prior consent and you can demonstrate it, it is a complete defense to liability and the strongest defense to liability. The level of consent is determined by the content of the message. As I mentioned before, if it is informational, it's prior express consent. Because these calls are informational, they're deemed by the FCC to be expected and desired of consumers, a lesser form of consent is required. A lot of these calls that are welcomed informational calls from nonprofits, political messages, survey results, payment reminders, fraud alerts, school notifications, etc. And in this instance, oftentimes providing a cell phone number for informational messages, providing a cell phone number or getting consent orally or in writing is considered consent for informational and transactional messages. However, it needs to be closely related to the purpose for which it was given. You have to pay attention to the scope of the consent given. So you can't get, for example, a telephone number for informational purposes and then use that for marketing or advertising purposes. You must abide by the scope of the consent as it was given. Often that scope is dictated in writing. That scope, if that consent was given orally for informational messages, then the circumstances of that consent will be important to determining what the scope of that consent was. So for telemarketing, they require prior or advertising calls or promotional calls. This is the definition that's currently on the books, and we'll talk about that and a change in that in just a moment. But it's an agreement bearing the signature of the person called that clearly authorizes the seller to deliver or cause to be delivered advertisements or telemarketing message using an ATDS or artificial or pre-recorded voice, and providing the number which the signatory authorizes such advertisements or telemarketing to be delivered to. They must clearly and conspicuously disclose that the agreement authorizes the caller to deliver the telemarketing call using an ATDS or artificial pre-recorded voice, and that the person is not required to sign or enter into an agreement as a purchase or condition of purchasing goods and services. So you can't condition obtaining consent on the provision of goods and services. And the agreement must, of course, include the number or and his or her signature. That can be a digital signature as well as defined by e-sign. Just to give you a new definition that was recently, there was in December of last year, the FCC issued a change to the prior written consent definition, which will become effective in January of 2025. I've highlighted those changes. I'll tell you the reason for that change in a moment, but let's examine that change. It injects into there an agreement that bears the signature of the person to be called or texted, making it clear that text messages are fall within the purview of the TCPA, that clearly and conspicuously authorizes no more than one identified caller to deliver or cause to be delivered the person caller texted ads or promotions or telemarketing messages. And then this bolded part, which is important, calls and texts must be logically and topically associated with the interaction that prompted the consent, and the agreement must identify the telephone number to which the signatory authorizes the advertisements or telemarketing messages to be delivered. Logically and topically associated. What the FCC is getting at here is the scope of the consent. It must be logically and topically related and associated with the interaction that prompted the consent in the first place. And so this is the FCC tightening the reins, as it were. Let me tell you why. In that regulatory decision that the FCC gave, they were concerned about lead-generated communications. They were wanting to, quote unquote, close the lead generator loophole. Many of you may be familiar with lead generation, but there, as you may know, businesses websites generate leads will not, under this new standard, will not be permitted to obtain a single consent to cover calls or text messages from multiple sellers. A lot of these websites are like a shopping comparison website, and previously to this loophole being closed, they would get consent to share information with partner companies or with marketing partners. What the FCC is doing here is closing what they perceive to be a loophole in the current state of the TCPA and advocating for one-to-one consent, which is consent from a single caller at a time. Again, it remains to be seen what the impact of this will be, but what is clear is, again, signaling a tightening of the reins on what the FCC considers to be prior express written consent. So something to keep in mind there. Okay, the Facebook decision. Landmark decision in TCPA law, which occurred 3 years ago. And although it was decided 3 years ago, its impact is still being felt today, which I'll talk about a little bit later. But this decision came down in April 1st, 2021, and adopted a narrow interpretation of the definition of the ATDS or auto dialer that we talked about earlier. It was a unanimous decision of the Supreme Court. It overturned a Ninth Court decision which broadly defined an auto dialer to cover any equipment that has the capacity to store or dial numbers, regardless of whether those numbers were generated by random or sequential number generator. This resolved a circuit split. It resolved an issue that had been hotly contested in the courts for 10 to 15 years. And it was and remains an important decision. Just a little high-level background. This was these were with respect to automated account alerts from Facebook to the plaintiff Noah Dogood in 2014, notifying that someone had attempted to access his Facebook account. But the problem was Dogood didn't have a Facebook account, never gave his number to Facebook, and claimed that Facebook claimed that Dogood had likely had a recycled number. Dogood was unable to stop these notifications and then filed a class action and alleged that Facebook violated the TCPA by maintaining a database of stored numbers and programming its equipment to send automated messages to those numbers. Facebook moved to dismiss, saying, essentially asserting that Facebook failed to allege that Facebook had used an auto dialer as that is defined, and instead sent targeted and individualized messages. The Northern District of California agreed and dismissed the lawsuit, but the Ninth Circuit reversed, stating that an auto dialer need not be able to use a random or sequential number generator to store numbers. It only needs to have the capacity to do so. Then the decision came down. The Supreme Court began by looking, as it does, at the statutory language. Again, this picture of clarity, not really, that the U.S. Congress had put together, unfortunately. And it basically said, look, store and produce are qualified by this modifying phrase, which is using a random or sequential number generator. That can't be ignored. The use of the comma suggests that Congress intended the phrase using a random or sequential number generator to apply to both of the elements preceding. And the court ultimately concluded that the auto dialer definition established by the Congress requires that in all cases where they're storing or producing a number to be called, the equipment in question must use a random or sequential number generator in order to be considered an ATDS. They basically said the expanded view of an auto dialer that the Ninth Circuit and others had espoused would take a chainsaw to these nuanced problems which Congress meant to use a scalpel for. And they said that this would capture virtually every modern cell phone if this is what the definition was, and would lead to an absurd result. So it struck it down. Struck down that definition, I should step back. It basically said it narrowed the definition in favor of a narrow statutory design that Congress employed to target certain calls. So what that means is that the automated calls or messages from a pre-existing list or a database of stored numbers, like which was used by Facebook, are not auto dialers and do not violate the TCPA. That is an important distinction. So the violation comes when there is those numbers are dialed or that they are gathered randomly using a random or sequential number generator, and then you're dialing those numbers, not when you are calling from a pre-existing list. So important decision, and really had an impact on that portion of the TCPA, the ATDS portion. Now, it's important to note that the Facebook decision does not and did not affect the TCPA's other provisions and requirements. So calls using artificial or pre-recorded voice to cell phones, or calls which are a telephone solicitation or text message to individuals whose numbers are on the do not call registry, are still in play, very much in play, in fact. The outcome of the Facebook decision is a shift in focus by plaintiffs' attorneys. There was, as you might imagine, an increase in focus of lawsuits on the other provisions, the artificial and pre-recorded voice provisions, the telephone solicitations to the do not call registry. Those two provisions it got an increase in focus, and most of the cases that come under the TCPA are under those two areas. And then, as you might imagine, a decrease in auto dialer related lawsuits. The other effect of this decision is, in addition to this shift in focus on the part of plaintiffs and plaintiffs' attorneys, is what many state legislatures did, and that was to create, in light of Facebook, a group of mini TCPAs, or what they're being called as mini TCPAs. Many states amended their statutes to inject a broader auto dialer definition, which was comparable to the broad definition in play before the Facebook decision. So Florida was the state that led, has really led out on this, and it incorporated a broad auto dialer definition, which includes any automated system for the selection or dialing of telephone numbers or a playing of a recorded message. So that conceivably could include dialing automatically from a list. Florida had dozens and dozens of cases there. In fact, by one estimate, over 500 cases filed in the first year that the mini TCPA was established in Florida. So it has been a hotbed area. Now, the business community must have pushed back on the legislature there, because the statute has since been amended again, and that amendment inserted a notice and opportunity to cure amendment, which is basically allows the prospective plaintiff has to provide notice to the business that he or she doesn't want to receive calls or text messages anymore, and allow them an opportunity to remove that person from the do not call list. And then and only then, if there is another call or text message to that individual, then and only then does the individual have the ability to sue under the Florida's mini TCPA. So there's been a retrenchment and a tamping down of lawsuits in Florida of its mini TCPA. Connecticut, these amendments went into play in October of 2023. It has an expansive call and text message definition. It broadly defines all telemarketing sales calls as calls made by way of live voice, automated dialing system, a recorded message device, a soundboard technology, over-the-top messaging, or text or media messaging. Very, very broad, and as defined, seems to conceivably cover every type of call there is. They have what is an eye-popping $20,000 statutory provision for violations. And enforcement can occur through a private right of action, and that because it can be enforceable under the state's consumer protection statutes, plaintiffs can be entitled to and recover their attorney's fees. So Connecticut making some noise of late. Maryland, same thing. This time last year, they amended their statute to inject a mini TCPA. It's nearly identical to Florida's auto dialer provision pre-Florida's most recent amendments. And then it also has, interestingly, a strict prohibition on the use of any sort of caller ID to block the identity, any efforts to block caller ID or block the identity or number of the caller. And that comes with a $2,500 per violation statutory penalty. A couple other states, and then we'll move on. Oklahoma, nearly identical to Florida's provision pre-amendment, and the state of Washington also put in place in 2023 a broader auto dialer provision. It also provided liability for those who assist in the transmission of solicitations, which I think is interesting. conceivably pulling in service providers. And then Washington, has a private right of action of $100 per violation and up to $1,000 for repeated violations. Other states have also made changes. New York, Arizona, Virginia. Some of those have private rights of action. Some of them don't. Arizona and I think Virginia, for example, don't have private rights of action, and they're only enforced by the only quote unquote enforced by the state's AG with civil penalties. But something to be aware of. There's a patchwork of many TCPAs developing across the country. All right, back to the federal TCPA. The other provision in place that you should be aware of that did not go away with the Facebook decision is the TCPA's do not call restrictions. The TCPA allows a private right of action for a person who's received more than one telephone call or text message within any 12-month period by or on behalf of the same entity in violation of the regulations provided under 47 USC 227C5. What are those prohibitions? What are those violations? Well, the TCPA prohibits any person or entity from initiating any telephone solicitation to residential or wireless telephone numbers of any individual who has registered his or her number with the National Do Not Call Registry. So it needs to be a telephone solicitation to those numbers, to someone's number who's on the Do Not Call Registry to be a violation. It has to be more than one call within a 12-month period. What's a telephone solicitation? Well, it's the initiation of a telephone call or message for the purpose of encouraging the purchase of goods and services. It doesn't include a call to, it has its own exemptions. It doesn't include a call to any person with that person's prior express consent. There it is. Consent is king again. Two, it doesn't apply to any person with whom the caller has an established business relationship. And I'll talk about that in a moment. And it doesn't apply to tax-exempt nonprofit organizations. Okay, what is an established business relationship? It is defined as a prior existing relationship formed by a voluntary two-way communication between a person or entity and the residential, I know it says residential, but it's residential and cellular subscriber without the exchange of consideration on the basis of the subscriber's purchase or transaction with the entity within 18 months preceding the date of the call. So if you have had a relationship, transaction, some goods and services exchanged within the previous 18 months of the telephone call being made, then you can fall under this established business relationship. Or if there's an inquiry or application provision if the call happens within 3 months immediately preceding, or excuse me, if there's an inquiry or application within the preceding 3 months, within 3 months immediately preceding the date of the call. So if you had someone call or inquire within the 3 months preceding the call, then that could be an established business relationship. The caveat here is that last line, which relationship has not been previously terminated by either party. And it can be terminated by the individual. The EBR, or the established business relationship, does not extend to affiliated entities unless the person would reasonably expect them to be included, given the nature and types and goods and services offered by the affiliate and the identity of the affiliate. So it is an exemption. It is not a very clean or clear one to prove to a court, and it would take time in the litigation to demonstrate this to a court. So it is an exception, and I don't want to mislead you that it's not, but it is one that can be harder to prove than prior express consent that you could have. Just a couple of other exemptions under the DNC. You wouldn't be liable if the caller can demonstrate that the violation was an error, it was a mistake, and you as an entity have written procedures to comply with the DNC rules, that you've trained personnel in the procedures established pursuant to the DNC rules, you have an internal do not call list, and that you access the national database. So there's a lot to that last exemption. It is, again, lots of boxes to check there. So let's shift gears a little bit and talk about the the healthcare specific exemptions which have been written into the TCPA. There's essentially three that apply to, and to be clear, these apply to the artificial and pre-recorded voice and the auto dialer provisions. The healthcare treatment exemption, the healthcare rule, and the healthcare messages to residential lines, which I'm not going to talk a lot about because in this day and age, there's not a lot of healthcare messages going to residential lines as opposed to mobile numbers. Let's dive in. The healthcare treatment exception. This exemption was established in 2015 and developed by the FCC in one of its declaratory rulings, and it has since been codified in the rules governing the TCPA. It exempts certain calls made by healthcare entities, and it exempts those entities from the prior express consent requirements. In other words, if you fall within the exemption, you do not have to have prior express consent to make these calls. These are calls, as you can see here, that have a healthcare treatment purpose. If you look at the list there, very clearly, appointment and exam reminders, pre-op instructions, lab results, home healthcare instructions, etc., have a pretty clear healthcare purpose to them. The FCC was very clear that this exemption doesn't cover calls related to accounting, billing, debt collection, etc., and it certainly doesn't cover telemarketing or solicitation calls. There are some strings attached to this exemption. These are those strings that are attached, and they are within the statute. It must be sent only to the mobile number provided by the patient. It's can't be charged against their call or against the mobile limits, which was once a big deal and is over time is less and less of a problem or an issue. It has to provide the name and contact information of the provider at the beginning of the call or text message. It must be a concise call or text message. It must be within call limits, only one call or message per day and no more than 3 calls or text messages per week. It must provide an easy way to opt out of receiving future messages. If it's an artificial call, voice activated or key press activated mechanism, or a toll-free number, if it's a text message, you've got to be able to reply stop or end or unsubscribe. And those opt-out mechanisms must be honored, and they must be honored immediately. And of course, you must comply with all HIPAA-related privacy rules in such circumstances. Other healthcare exemptions include the healthcare rule, as this covers calls and text messages using an auto dialer or an artificial or pre-recorded voice that delivers what's known as a healthcare message from a HIPAA-covered entity or its business associates. These types of calls are still subject to TCPA liability, but they only require prior express consent rather than prior express written consent. And as I mentioned earlier, such consent is often shown by the call recipient providing his or her mobile number at the time of treatment or service. And so what's a healthcare message for purposes of this healthcare rule? Well, it's what you might imagine. It's defined, HIPAA defines healthcare as health services, supplies related to the health of an individual, and includes this list of of items or categories, which I won't name out loud for you. It's what you would expect it to be. Courts have weighed in on this. The Second Circuit has weighed in. It addresses the individual's healthcare needs. It addresses a healthcare product or service made by or on behalf of a healthcare provider with a business relationship or a treatment relationship. And then again, the other exemption is calls to residential lines, very similar to the other exemption, only this one applies to residential lines. And again, this is a technology and the way things are moving that just doesn't apply as much anymore. I'm going to actually skip this one. There is an emergency purposes exemption, but it is very, very narrow. It only applies to true emergencies, calls necessary affecting the health and safety of consumers. This was opined upon by the FCC during the pandemic. There were lots of pandemic-related communications which exempted certain calls and messages, and really for your purposes would be rarely used exemption. Actually, for the sake of time, I'm going to skip through this example, but it's basically an example of where a court upheld the healthcare treatment exemption. This involved Rite Aid. There was a flu shot reminder, which was a pre-recorded one made by or on behalf of a HIPAA entity. And Rite Aid was sued for this. The courts, both the lower court in the Southern District of New York and the Second Circuit, upheld the exemption and exonerated Rite Aid. I do want you to be careful. There are some courts, and again, this case is a little bit dated in TCPA parlance, but there was a similar case where the healthcare rule was found not to apply, and neither did the healthcare treatment exemption, but that was because there were things that were not met as part of those exemptions. Anyway, I'm going to move forward. A word about revoking consent. The FCC issued a ruling on consent and what that looks like and what revoking consent looks like. They made it abundantly clear this was a 2024 ruling, that consumers may revoke their consent to receive calls and texts by any reasonable manner that clearly expresses a desire not to receive future calls or text messages. That may be obvious, but there were some entities, I think, that were trying to say, well, they didn't really expressly, they didn't say stop. They said quit or cancel on the text message, and so they didn't really opt out. This puts all of those questions to bed. You have to provide a mechanism for them to revoke, and they're looking at the reasonableness of this. And you can do that either by key press activated opt-out, by responding stop, quit, revoke, opt-out, cancel, etc., or submitting an opt-out via a designated website or phone number. And the FCC was very clear about honoring those revocation requests and put in place a outlier 10 business day time frame to do so. But all of these should be responded to quickly and efficiently, or risk of further risk of liability. One last word that they made about post-revocation communications. You can send a one-time post-revocation text message confirming the revocation request. It can't have any marketing or anything else in it. It just confirms the opt-out request and says, are you sure? It may include a request for clarification on the scope of the opt-out. So let's say that a consumer consented to multiple types of messages with your entity. Maybe they've wanted healthcare updates. Maybe they have consented to some marketing. You can have a text message that clarifies the scope of that opt-out in a post-revocation communication. Okay, no One last footnote, no presentation in 2024 would be complete without some mention of AI. So here you go. Here is your AI pointer of the day. In February 2024, the FCC confirmed that the TCPA applies to AI technologies that generate human voices. It clarified that AI-generated voices are considered artificial or pre-recorded under the TCPA's provision. The FCC is concerned about the rise of these types of calls, which have escalated in the last few years, including, sadly, the potential to confuse customers by imitating voices of, including close family members, celebrities, political candidates, etc. And the FCC wanted to make it clear that all of the requirements that apply to artificial or pre-recorded voices, prior consent, identity and disclosure, opt-out requirements, they all apply to AI messages. And so, it may seem obvious, but this is, again, the FCC making sure that everyone is clear that although there has been an update in the technology, that the opt-out, or excuse me, that all the requirements that have always applied to artificial or pre-recorded voices under the TCPA still very much apply to this updated technology. So there you go. There's your AI tip of the day. Finally, best practices, do's and don'ts. I think it behooves you and your organization to develop and think carefully about TCPA and developing a compliance program. You ought to think carefully about obtaining written consent prior to initiating or sending promotional or advertising calls or text messages to customers. You need to have one or more opt-out mechanisms with those calls or text messages. You should have in place procedures for tracking revoked consent or opt-out messages and honoring them. The biggest piece of trouble that people and entities get into is when they continue to text or call when the consumer has clearly indicated that consent has been revoked or they have opted out. That's where a lot of trouble happens. Be careful to categorize your messages and to keep informational messages content neutral. Don't include, as I mentioned before, if you include promotional material with an informational message, the courts and the FCC consider that to be a dual purpose message and, in fact, a promotional message. And then work to make those consent forms clear, conspicuous, user-friendly. This is an important record that if, heaven forbid, your organization was ever sued for TCPA violation, you could pull out and say, we had the necessary consent required under the TCPA for us to send the messages we sent. Very, very important to look at that. Again, you grow tired of me saying it, but consent is king. One thing you need to stop doing, and I should mention, these are best practices for minimizing, and I'll go back to my last slide, for minimizing TCPA and mini TCPA liability. I will tell you, and I wanted to mention this, many of the statutes, the mini TCPA statutes, have within them similar consent requirements or consent exemptions. And so that's why consent is important. Some of them have established business relationship exceptions comparable to the TCPA. Some of them do not. And so it's hard to rely on that established business relationship because the state statute, the state mini TCPA may not have that exemption within it. But as I have looked at the state statutes, many of them have these prior consent exemptions written within them. Don'ts, things you should avoid. You need to be clear and careful with respect to the consent that you have received in the past and make sure that it is valid today. And take a careful look at that. You should be careful about placing unnecessary restrictions on the scope of consent. Again, the consent needs to be topically related to the services or the reason that the individual contacted you in the first place. That's what courts will look at. What is the scope of consent here? And you should not assume that you have broad consent if in fact you have a narrow consent, because messages outside of the scope of consent will not be covered by that consent, and raises the risk of liability. Don't assume that there's no violation because you're not using an ATDS. We spent some time going over the other aspects of the TCPA, which very much apply in the wake of the Facebook decision. And so while that aspect has waned, the others have come into the forefront. And don't assume you're safe from liability by using a third-party marketer or vendor. I think you need to be deliberate about one, who you use and whether that vendor is looking into some level of TCPA compliance. Some of that, there is some vicarious liability which can occur, and I won't bore you with the details of that, but it can go upstream as well as down. So that is my presentation today. I noticed there are some questions in the chat in the last 5 minutes. I'll take a look at those and see what I can get to. Any that I'm not able to get to before we close, I can address separately. I'll have your information to be able to address those. But so one question, I may have missed it. Do many TCPAs apply based on where the person receives the call is located, or where the call is initiated? It is where the person is located, the residence of the person. Well, it's where the person is located. If they are, say, a Florida resident, then the mini TCPA can apply. Or if they have a Florida telephone number, there can be application of that mini TCPA. There's some case law that indicates that, well, if their number's there, that indicates some sort of residency. And now I understand your concern that there are folks that move all the time and keep their old numbers, but I'm just telling you what the case law will look and examine where that person is and what that number means to where that person is. But if you're sending messages into those states where there's many TCPAs, you need to assume that there could be liability with respect to those folks. Regarding provider name, does it need to be the doctor's name, or is the entity sufficient? In my experience, I think the entity is sufficient, provided that the person to whom you're sending the text message understands that who that entity is. They need to know this is coming from the doctor's office that I visit. It doesn't need to necessarily need to be the name of Dr. Smith, but that person needs to have an understanding, or you need to assume that they'll understand that they'll recognize the name of the entity that they visit. And I'm sure they do, based on billing and other information. Well, those are the two questions that I had. Unless there are other questions that you want to submit in the chat, let me just make sure I didn't miss any. I think that's it. I will give you back the last 2 minutes of this hour. Thank you very much for joining me today. If you have any questions, you can, again, reach me offline by that email address and by the LinkedIn profile there. It's been my pleasure to talk to you today, and best of luck to you in your various endeavors. Have a great day. See you later.